Hello, everybody. My name is Elizabeth Gallagher, and I'm a paralegal here at Lyles Parker. Thank you for joining us today for the webinar hosted by the Home Care Association of Louisiana. Today's webinar is entitled Improper Home Health and Hospice Marketing Practices Seen Around the Country. Are your marketing practices consistent with the Anti-Kickback Statute Safe Harbor requirements? Today's presenters are John Pierce and Ashley Morgan, and I will tell you a little bit about them. Ashley Morgan is a partner in Lyles Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. John Pierce is an experienced former federal prosecutor and trial attorney whose practice focuses on sophisticated criminal defense and civil litigation. His background is rather unique. Prior to entering private practice, Mr. Pierce served as an assistant U.S. attorney for a total of 14 years in the Southern District of California, the District of Columbia, and in the Eastern District of Virginia. In San Diego and DC, his focus was organized crime. Oh, sorry, dog. Sorry about that. In the Eastern District of Virginia, his focus was healthcare fraud and served on the Attorney General's Advisory Committee for Healthcare Fraud. Since leaving the government, Mr. Pierce has successfully represented both foreign and domestic individuals and corporations in healthcare, commercial securities, corruption, export control, and tax disputes. He's also handled a number of whistleblower cases. So without further ado, one more thing. Quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box and we will address as many as possible at the end of the presentation. Now, without further ado, I present your speakers, Ashley Morgan and John Pierce.
Thank you so much, Liz, and thank you all so much for being here today. As Liz said, John and I are going to be chatting with you today about improper marketing practices that we're seeing around the country. And making sure that your marketing practices are compliant so that you don't find yourselves in a issue with civil or federal statutes and laws. Thank you all so much. Go ahead and go to the next slide, Liz. Okay, so just a brief disclaimer. This outline is provided as general information only. It does not constitute legal advice and should not be used as a substitute for legal counsel. While we are attorneys, we are not your attorneys. Outcomes can differ for different people depending on specific facts. We always encourage you to reach out to your own independent legal counsel about specific issues and questions. Next slide. So just a little outline of our agenda for today's webinar. First, we're going to talk about some types of relationships that can create risk, the applicable laws to these types of relationships. Interpretive guidance, things that are out there that can kind of guide us on what we can do and what we can't do, and some tips on how to craft compliant arrangements. Next slide. So just some examples of some problematic practices that we see for physicians, specifically sham medical directorships. Obviously, if you are home health or hospice agency, you likely have a medical director that's working with your agency. The physician, if they're being paid for really no services, or they're being paid for overpaid for the services that they're actually providing, that can be obviously very problematic. It's something that we do see quite often, unfortunately. Another situation can be multiple medical directors with compensation based on the volume or value of referrals. As we're going to talk further today, that is in direct conflict with some of the laws that are governing these types of relationships and anti-kickback practices, for example. Another area where we see problematic practices are with marketers who are going out talking to potential referral sources in the community, excessive payment for space rentals to facilities with potential patients. That can be considered an improper marketing practice. Obviously, paying marketers improperly can be considered improper, paying them based on the volume or value of referrals potentially, and also giving gifts to referral sources and patients. If the marketers are doing that, that can be very problematic. Next slide. For facilities that y'all might be working with, if you have agreements with nursing homes to send patients to your agency, that's something that we do see that is very problematic. If you're renting space at a nursing home, for example, it needs to be fair market value for the amount of space that's being leased. Excessive rent for an agency space is considered a violation. Another issue that we see is free or below market value services that could be provided by a hospice to a nursing home. Referring a home health or hospice patient to a nursing home in exchange for a nursing home referring a hospice patients, and an agency going through medical records of a skilled nursing facility or an assisted living facility to specifically look for referrals without specific patient permission. Obviously, that sounds problematic on the face. There's all sorts of problems with sifting through somebody else's patient records, especially with HIPAA as well. But another thing that we cannot be allowing people to do to look for potential referral sources. Next slide. Okay, so first we're going to talk about a case study. This case actually happened in Texas. It's a pretty well-known case. Y'all might be familiar with it. It was the Jacques Roy case. Dr. Jacques Roy had over 11,000 patients, and he was affiliated with over 500 home health agencies in Texas. The home health agencies were referring patients to Dr. Roy, who would then refer them back to the home health agency. Dr. Roy had referral arrangements with multiple home health agencies. Home health agency personnel were driving around Dallas homeless shelters offering food stamps or to buy individuals groceries. One home health owner was paying recruiters $50 and offering to buy homeless patients McDonald's. Other home health agencies went door to door looking for Medicare beneficiaries, knocking on the door, asking if people were Medicare beneficiaries. In connection with this investigation, it was uncovered that some of the home health agencies that Dr. Roy was affiliated with were receiving 80% of their patients from Dr. Roy. Sometimes when you're in a rural area, you can have a situation where a majority of your patients are coming from one doctor just based on the area that you're in. But, Dallas, isn't exactly rural. There's lots of doctors available. So 80% of the patients from one doctor, and him, having multiple places where he's sending 80%, that's an immediate red flag for an investigating agency looking into this specific issue. Dr. Roy's office was handling more home health visits than any other physician's office in the country. With this volume, he had employees fraudulently signing his name to plans of care and certifications. The government was able to use data analytics to identify the fraud. Obviously, he was a big outlier. He was doing tons of visits. It's really easy to spot impossible day visits. It's easy to see that he is referring patients. He's the referring physician on all these plans of care for all these agencies in the area for a majority of their patient population. One thing that the government is really good at is maintaining data and looking at data. So they were able to use that data, that claims data, to identify this issue and then conduct a further investigation. In reviewing the case, the OIG that said that most physicians refer fewer than 100 patients for home health, where Dr. Roy had 11,000 patients. Obviously, that's a dramatic difference. When Dr. Roy's first practice was suspended in connection with the investigation, He went on to create a second practice, which was paying significant management fees to the original practice, essentially to try to skirt around the suspension issue and to continue to get money in. Dr. Roy was ultimately sentenced to 35 years. Others who were involved in this arrangement were sentenced to 3 years and up to 17.5 years. Dr. Roy was ordered to pay $268 million in restitution back to the government for this referral arrangement that he had. Next slide. Okay, the next case is U.S. ex-rel accordingly. And the ex-rel typically means that this is a whistleblower case. It's a case that the government took on behalf of the whistleblower named accordingly, and it was versus Good Shepherd Hospice. This was in Missouri. Good Shepherd was a hospice that was based in Oklahoma City. It provided services in Oklahoma, Texas, Missouri, and Kansas, had 15 different offices. The whistleblower was the executive director of one of the offices for only 6 months. You know, it doesn't always take a lot of time to identify problems when you're working in a facility. This hospice specifically was hiring medical directors that specifically based on their ability to refer patients to the hospice. They were focusing on medical directors that had ties to nursing homes. The hospice had 4 to 5 medical directors who each only were working 2 hours per month, but were being paid a $3,000 salary every month. So they were getting paid $3,000 for 2 hours of work. That seems like a very high hourly rate for a medical director position. The hospice was requiring medical directors to refer 1 patient per month. One medical director was terminated for failing to bring in referrals, and he subsequently expressed his concerns about the quality of care as a reason for not referring patients, you know, that the care that the hospice was providing. The hospice would keep at least 1 patient in a nursing home as a hospice patient so that they would have access to the nursing home to continue to market their hospice services. Next slide. The hospice nurses were also performing the work of nursing home nurses when in the facility, treating the hospice patients. There's a quote that we have from this case that's, where they're saying, if you give me 5 patients, I'll put a nurse's aide in your building all day long. Obviously, you know, a hospice can't provide staff for a nursing home. That's an inappropriate arrangement. They were also providing expensive brooded chairs free of charge. The hospice was also paid for residence room and board, even if it did not receive Medicare payment due to faulty paperwork. Hospice consultants, which were essentially marketers, were giving nursing home staff gift baskets and free lunches in order to achieve a quota of 5 admissions per month. Good Shepherd Hospice has ultimately settled this case for $4 million and also had to enter into a 5-year corporate integrity agreement, which typically involves ongoing claim reviews of contracts and marketing agreements that you have to share with the OIG during that 5-year period and get approval for. Next slide. Okay, one more case study for you. This case is U.S. versus DeBoer and Whitaker. This also took place in Texas. John DeBoer owned Care Committers Health Services, Inc., and DeBoer and Whitaker paid group homeowners for access to and for referring Medicare beneficiaries up to $500 for an initial certification and $250 for a recertification. Payments were being made in both cash and check. DeBoer paid marketers and recruiters, including Whitaker, to find beneficiaries. Beneficiaries were paid to sign blank home health forms. DeBoer was ultimately found guilty after a 4-day jury trial and sentenced to 9 years in prison and $3.5 million in restitution. So there's just some, you know, fairly egregious examples, but we just want to kind of give you an idea of some relationships that we've seen in cases in real life. And now we're going to talk a little bit about some of the applicable laws. Next slide.
All right, shall I take it from here, Ashley?
Absolutely.
So, folks, this administration has issued memoranda stating that they are prioritizing healthcare waste, fraud, and abuse. They're prioritizing the resources to investigate it. It's always been something investigated and prosecuted, but this administration has it as their #1 priority. They haven't publicized it as much yet, but we certainly anticipate that you'll see many more press releases going forward about task forces that are being put together and then deployed on various types of what they consider schemes to try to raid the Medicare and Medicaid trust funds. The rules and the laws are sometimes complicated. That's why you should never hesitate to reach out to counsel for assistance to figure out when you have a question. And one of the curious things about healthcare is that conduct that can be prosecuted criminally is frequently the same conduct that could also just be brought as a civil matter where only money is at stake rather than money and liberty. So just something to be on the alert for is that conduct that's under scrutiny, depending on who's taking a look at it, the target is going to either be over on the civil side of the U.S. Attorney's Office or the criminal side of the U.S. Attorney's Office, or both. Next slide. The investigations and prosecutions in healthcare fraud include home health agencies, and there are lots of what the government considers routine schemes that they're on the lookout for. And auditors are going to be deployed all the time to take a look at records if they see anything or smell anything fishy. Ashley had referenced earlier analytics, and what the government, it's not necessarily high-end analytics, but what the government will frequently do is just look for what provider is billing more of this than anyone else. It doesn't matter if it's a dentist, it doesn't matter if it's a surgeon, it doesn't matter if it's a home health agency. If there's a provider who's providing and submitting so many more claims than anyone else in the field, it's just going to throw up a red flag with their little analytics triggers, and there's going to be an investigation. So with the earlier example that Ashley showed you, if the average physician makes 100 referrals, and then there's a physician making 11,000 referrals, there's going to be a red flag. So if there is anything that you're involved in where you think, man, I am killing it, I am way ahead of the market in this, then just make sure you might want to just check in with your attorney and say, I just want to make sure that everything's okay here because I seem to be making a ton more than anyone else in this particular area. Next slide. So some of the most frequently used statutes that we see in this area, in the criminal arena, it's going to be, I'll do the second one first, criminal healthcare fraud, section 1347. It's a newer addition to the criminal statutes relative to like wire fraud and mail fraud. Shoot, mail's hardly even used anymore these days, but that was still the original statute that was most frequently used by federal prosecutors. But healthcare fraud it's very broad that the government can use it in almost any circumstance. Anytime that there is a material representation that was intentionally made with the intent that the person to whom the representation is made relies on it, and that person does rely on it to their detriment, that can qualify as a fraud. And in the healthcare context, if there is a claim, a submission of a claim for payment on home health care that was based on and and derived from, let's say, a kickback, well, that's going to be a claim that was submitted without the person paying it knowing that, oh, well, this was actually sent to us by a doctor that we were paying on the sly. So that would be considered fraudulent conduct, and that could be brought under 1347. The anti-kickback statute could also cover that same conduct, where anytime there is a benefit of some sort extended to a provider in exchange for a referral, referrals, the payments can never be based on volume or value. And particularly in the marketing sense, that's what we're going to hammer on you all the time. So in the kickback sense, anything of value that's provided could be covered under the anti-kickback statute. And the theory with that, you probably all know, the theory is we want physicians, we want providers making medical decisions without any influence but their own medical judgment about what is necessary in this circumstance. So if, you know, whether it's time for home health care, whether it's necessary, those decisions the government wants made completely independent of any kind of incentive that a home health agency may be extending to that referring physician. In civil laws, physicians can't self-refer to themselves. Those are stark violations. The False Claims Act in a home health agency arena is anytime there's a claim for payment by the government, or a reverse false claim is when there's the government's supposed to be paid and it's avoided. But in this context, anytime a claim is submitted for payment and there is false information on which that claim is based, like, oh, well, we paid physicians based on volume to send us referrals, that conduct can then be brought under the False Claims Act, which has treble damages, which means that, you know, if a violator brought in $50,000 based on false claim submissions, they're subject to a penalty of $150,000. So the government will make you pay for conduct that it considers inappropriate based on false claims. And the thing to flag for you is that any conduct that somebody could fall under the False Claims Act in the civil arena could also be brought as a criminal matter. So, you know, just be aware, be alert that we hear it all the time from clients who say, why am I being prosecuted criminally when Joe Schmo down the street did the same thing and he just had to have you deal with a civil case. So it's the same conduct. And then, of course, HIPAA are other civil laws that need to be complied with, or else you bear potential civil penalties from the government. Next slide. So with the criminal anti-kickback statute, it prohibits anyone from knowingly or willfully soliciting, receiving, offering, or paying any remuneration. So that's anything of value in order to induce somebody, something, in order to provide a service that's payable under a federal health care program. So this does happen to relate just to federal programs like Medicare, Medicaid, but there are other statutes that make the same thing criminal under, even if it's a private payer, like an insurance company. So if there are such transactions, anyone involved on either end of the transaction can be prosecuted under the anti-kickback statute. So if it's a marketer who receives payments improperly for referring patients, they can be prosecuted. And if it's the home health agency receiving patients, they can be prosecuted. No need to remind you that when somebody is convicted criminally, that incarceration can be a result, plus fines, plus forfeiture, which is the disgorgement of ill-gotten gains, but more importantly, restitution. So every amount that the government paid is then has to be recouped from the person convicted. So we unfortunately deal with cases where the government claims that the scheme costed hundreds of millions of dollars, and then every person, right down to the last marketer who may have referred $100,000 worth of patients, every person convicted is jointly and severally responsible for the restitution. So each person convicted is going to be responsible for, let's say, $150 million to be paid back after release from custody. So it's a penalty that never stops giving. Next slide, please. Now, they changed the intent requirement for the anti-kickback statute from what's called general intent, or from specific intent to general intent. So it used to be that you had to know that you were actually violating a particular law, that is the anti-kickback statute. Now you just have to know that you have committed the conduct that's in violation of the law. So your knowledge is only, this is what I did. I, received money in exchange for referring a certain number of patients. So you knew you did that, you just didn't know it was against the law. Well, that brings you under the scope of the anti-kickback statute now. Next slide. Now I'm going to have Ashley address safe harbors, but let me just make one mention about safe harbors before she does. Safe harbors are carve-outs that say, well, it's not illegal if these conditions are met. And what we so often see in our practice is that, particularly with marketers will be told, look, tell you what, just we're going to pay you for the number of patients, but just say that you're being paid hourly. So when you prepare the invoice, just prepare it like it's numbers of hours worked, and we're going to pay you, X amount per patient, but you just call them hours. And so the person who's telling the marketer to do that is trying to find a safe harbor that makes the conduct okay, but really what they're doing is just disguising volume or value within a safe harbor that doesn't actually exist. And so often, if we're representing a marketer, we'll be told, yeah, but they told me that their lawyer looked at it and approved everything in the contract and the way we were invoicing it. Well, that's another good reason to always, if somebody's giving you a contract saying, this has been blessed by my attorney, get it blessed by yours as well. Because what we see so often is that the person providing the contract, yeah, it was probably created by a lawyer at some time in some place, but not for this instance. And the person has just taken a contract, made changes to it that they think make it fit, and then given it to someone who says, it's okay, my lawyer has already vetted it. Yeah, so often it's not true. Ashley?
Thank you, John. I certainly agree. And it's also important to think about the fact that, if you're provided a contract on paper, you actually need to follow the contract as well. A lot of times we see a contract that may meet these safe harbor requirements on paper, but what's happening in practice isn't necessarily what the intent of the contract when it was written was intended to do. We're going to talk about a few of the common safe harbors, bona fide employees, personal services and management contracts, space lease, and investment interests are the ones that are most applicable to these situations and the ones that we most commonly see used. There are new safe harbors that are added periodically, so it's important to be aware of changes that are being made. And another important thing about these safe harbors is they have very specific requirements. And in order for the safe harbor to actually apply, you need to make sure you're meeting all the parameters. So Liz, let's go ahead and go to the next slide. All right, so this is the Personal Services and Management Contract Safe Harbor. This is a really fancy way of saying it's a safe harbor essentially for 1099 employees, agents of your agency, but people you're paying as a 1099 employee. In order to have that relationship fit within the Personal Services and Management Contract Safe Harbor, you need to meet all of these specifications that are on the screen. There needs to be a written signed agreement. That agreement needs to be for at least a 1-year period. It cannot be for a shorter time period. It can be for longer, but it has to be at least for 1 year. It has to cover and specify all of the services that that person is going to provide for the term of the agreement. The methodology for determining the compensation that's going to be paid to the agent over the term of the agreement has to be set in advance and has to be consistent with fair market value in an arm's length transaction. It cannot be determined in a manner that would take into account the value or volume of any referrals or business otherwise generated between the parties for which payment may be made in whole or in part by Medicare, Medicaid, or other federal health care programs. You can have somebody assist you with determining what the fair market value would be. I highly recommend bringing in somebody to help you do that valuation. But it's important that we're not taking into account, you know, this is what we would make for 30 referrals, so this is what we're going to pay you, and you need to give us 30 referrals, but we're not going to put that in the contract. That's not appropriate. It cannot involve counseling or promotion of a business arrangement or other activity that violates state or federal law. And the aggregate services do not exceed those which are reasonably necessary to accomplish the commercially reasonable business purpose of the service. So the services that are being provided, you know, they have to be what would be expected of a person in this position to actually provide the services that are being requested, and the pay has to be fair for the services that are being requested. Next slide. Space lease safe harbor. It can certainly be kickbacks can be considered for paying more than what we would consider to be fair market value for a lease agreement. In order to meet the safe harbor lease agreement, you need to have a written agreement again that's signed by all the parties, and the term of the contract needs to be for 1 year. That's a common provision. The agreement needs to be specific. It needs to cover all of the premises leased between the parties. Any part-time leases also need to specify the exact schedule for the use by the parties. The aggregate rent needs to be set in advance. It has to be consistent with fair market value, again, in an arm's length transaction, and again, cannot be determined in a manner that takes into account the volume or value of any referrals or business otherwise generated between the parties for which payment may be made by the federal health care programs. The services performed under the agreement do not involve counseling or promotion of any business arrangement or other activity that could violate state or federal law. And the aggregate space rented does not exceed what is reasonably necessary to accomplish the commercially reasonable business purpose of the rental. So if you're just renting, you know, a small space for a single person to sit in, you know, a single person doesn't need an entire floor of a building. So the space that's being rented needs to be appropriate for the amount of people that are going to be staffing it and for the work that's going to be done in that space. And again, we highly recommend that if you're entering into an agreement like this, again, you're working with an attorney and that you have somebody do the valuation for what the fair market value would be for that space rental. Next slide. So employment, there is an employment safe harbor for your W-2 employees. In this instance, remuneration under the anti-kickback statute, it does not include any amount paid by an employer to an employee who has a bona fide employment relationship with the employer. So a bona fide employee, how do we define that? You have to look to the IRS test at, we have the code provision for you on the screen, 26 USC section 3121 D2. There are a lot of factors that are outlined there for what would be considered to be a bona fide employee. We have a couple for you on the screen, but this comes up quite often in marketer and kickback cases where fees were commission or success-based, because you can pay based on a commission or success-based payment for a bona fide employee, but again, the factors need to be met. The factors that are going to be looked at to determine whether a person was really an employee or just, you know, a 1099 that you're trying to disguise as an employee is the form of payment. Was it hourly or was it pure commission compensation? Did the alleged employee have an office at the employer's location? Did they receive any training? Did they set their own hours or work full time? Did the employer pay for the expenses of the alleged employee? There's some other ones as well, such as, you know, whether they had paid time off, whether they had health care. So very important provision there. If you have bona fide employees that you're going to be paying on a basis that may vary, and very, very important that we have an attorney involved in those conversations to ensure that we're meeting the requirements to ensure that those relationships do in fact fall under the employment safe harbor. Next slide. Okay, so the Stark Law, I'm sure everybody on the call today has heard about Stark Law. It's very heavily talked about. It's actually pretty narrow, but it's very complex to apply. It does not apply to hospice. So if you are only a hospice provider, you do not need to worry about the Stark Law. It does, however, apply to home health services. Home health is a DHS, a designated health service. There are about 18 DHS designated health services that are identified under the Stark Law, and physicians are prohibited from making referrals to DHS entities in which the physician or a member of his or her family has a financial relationship, unless there is a specific exception that applies. There are considerable penalties for violating this law. You can be asked to pay up to $15,000 for each claim submitted in violation of the law, up to $100,000 for each scheme that violates the law. Can be a denial of payment for the designated health services and a request to refund all amounts paid. Treble damages can be imposed, and there is exclusion from the federal health care program. Next slide. A couple key terms for you. We already talked about DHS, but a financial relationship, that means compensation, ownership, or investment interest. This typically is going to pertain to medical directors. Stark Law applies to a physician financial relationship if that physician will ever refer Medicare patients to a home health care agency. This is a strict liability civil statute. If you violate Stark Law, it results in the obligation to refund all payments by the home health agency and possible fines. So essentially, you either comply with Stark Law or you don't. If you don't meet an exception and you're found in violation, you're liable. Strict liability, that's essentially what that means. Thank you, Liz. Stark Law exceptions are very similar to the safe harbors that we just talked about for the anti-kickback statute. The commonly used exceptions, again, are the personal services arrangements, office space, equipment leases, bona fide employee relationships, non-monetary compensation, and investments in rural providers. We're not going to go through all of these again. Again, please consult with your healthcare attorney if you do have employees, especially if you're a home health agency that has medical director relationships, to make sure you're not in violation. But again, these safe harbors are very similar to the ones we just discussed for the anti-kickback statute. But again, you have to comply with every single provision of that safe harbor to be considered in compliance. Next slide. Okay, so Louisiana laws. This is just a sampling. Many states have companion laws, their own laws for the False Claims Act, for the Anti-Kickback Statute, but it really varies state to state what the law says. Some states have all payer laws, for example, Texas does. Some states, their healthcare statutes only apply to Medicaid. Here in Louisiana, we have the fraudulent remuneration statute. This is a criminal law, and there's also a civil component. This is similar to the Federal Anti-Kickback Statute. It permits any arrangement or practice permitted by Federal Anti-Kickback Statute safe harbor. So again, if you're in compliance with the federal law, you should be good under Louisiana law. It applies to Medicaid referrals specifically. The civil statute in Louisiana is a strict liability statute, meaning there's no intent to violate the statute required to be proven by the government. Although the implementing regulations appear to add a knowing and willful intent requirement. So there is language in there that does look like they will consider intent, but again, it's written in a way that the civil statute is a strict liability statute. So if you're in violation, they don't have to prove that you intended to violate the statute. Again, that's going to be different for criminal, but for civil, strict liability. There's also a Medicaid fraud statute that is criminal and civil and is very similar to the Federal False Claims Act in Louisiana, but it's going to obviously just apply to Louisiana Medicaid claims. Next slide. Okay, so now we're going to go through some interpretive guidance. We've got quite a few for you. I'll try to cover them fairly quickly, but these are essentially materials that have been released by the federal government over years and years on specific issues they're seeing, ways that you can make sure you're in compliance. So next slide. Okay, so first we're going to go through some OIG compliance materials. We've got some specific compliance materials released by the OIG for hospices and for home health. We've got compliance program guidance, we have fraud alerts, and you'll see a lot of these date back quite far. The original fraud alert for home health was back in 1995. So next slide, Liz. Okay, so we're going to start with home health and go ahead and go on to the next slide. Okay, so this is a fraud alert, again, that was issued in 1995 for home health agencies. The OIG specifically announced that it saw that home health agencies were offering kickbacks to physicians, beneficiaries, and hospitals and rest homes in return for referrals. Examples were provided of conduct that the OIG was seeing that they thought was problematic, which included providing hospitals with discharge planners, home care coordinators, or home care liaisons in order to induce referrals, providing free services such as 24-hour nursing coverage to retirement homes or adult congregate living facilities in return for home health referrals, subcontracting with retirement homes or adult congregate living facilities for the provision of home health agencies, home health services to induce the facility to make referrals to the agency, or pressuring physicians to order unnecessary personal care by telling them that their patients were requesting services and that they would refer those patients to other physicians unless the physician ordered them. So obviously some very improper practices here, but again, this conduct has been on the radar for the OIG for a very, very long time. So many of the arrangements that we see that are problematic today are not new, and the OIG is aware of them and regularly conducts investigations to ferret out this sort of behavior. Next slide. Okay, so 3 years later, 1998, the OIG released its compliance program guidance for home health agencies. This is a very helpful document. It discusses potential risk areas along with some sample policies that a home health agency should implement in order to maintain compliance with federal laws and regulations. Some of the risk areas that were identified for agencies to take a look at were home health agencies providing incentives to actual or potential referral sources, including physicians, hospitals, patients. For example, paying a fee to a physician for each plan of care certified, providing nursing or administrative services for free or below fair market value to physicians or hospitals, providing salaries to a referring physician for services either not rendered or in excess of fair market value. Those are those medical director relationships. Some other areas that were identified were services provided to patients who resided in assisted living facilities. A specific area here is obviously that space rental issue that we talked about before. If that doesn't meet the safe harbor, that can be considered a violation. And providing services that are otherwise covered under the resident contract or required under state licensure. The OIG also specified compensation programs that offer incentives for a number of visits performed and revenue generated as problematic. Next slide. Some policies that the OIG recommended that agencies implement to maintain compliance were that all of the agency's contracts and arrangements with actual or potential referral sources were reviewed carefully for compliance with applicable statutes and regulations, those safe harbors, making sure they comply. That the agency does not submit or cause to be submitted to the federal health care program claims for patients who are referred to the agency pursuant to contracts or financial arrangements that were designed to induce such referrals in violation of the Anti-Kickback Statute or other federal or state laws, and that they're not offering or providing gifts, free services, or other incentives to patients, relatives of patients, physicians, nursing facilities, etc. That would be a violation of the Anti-Kickback Statute or federal or state laws or regulations. Next slide. This is our last sample guidance for home health, but an OIG alert that was issued in 2016. It involved the improper arrangements and conduct involving home health agencies and physicians. The alert specifically focused on studies of home health agencies and physicians and home visiting physician companies. We've got the link for you if you want to go check it out for yourself. But there were criminal convictions and settlements that were discussed within this alert. And some of these arrangements included making and accepting payment for patient referrals, falsely certifying patients as homebound, and payments for referring or soliciting Medicare and Medicaid patients, sometimes involving payments to physicians disguised as payments for serving as medical director. So again, those medical director contracts. We see requests for them all the time in fraud investigations. They want to look at the contracts. Please make sure those are compliant. Next slide. Okay, so now we're going to talk about some hospice guidance that's been issued. So next slide, we're going to follow a similar pattern here. OIG fraud alert that was issued in regard to nursing home arrangements with hospices. This was issued in 1998. The OIG specifically stated that it was seeing instances of kickbacks between hospices and nursing homes to induce referrals. Specifically, the OIG identified payments being made by a hospice to a nursing home for room and board provided to a Medicaid hospice patient. That should not exceed what the nursing home otherwise would have received if the patient had not been enrolled in hospice. Payments must represent the fair market value of the additional services actually provided to that patient that are not included in the Medicaid daily rate. So again, 1998, this goes back a very long time. Fair market value, that is a very, very important number to know. What is the fair market value for the services that you're providing, and you need to abide by that and make sure the services are actually being performed. Specific practices, which are suspected kickbacks, which were identified in this fraud alert, included offering free goods or below fair market value goods in order to induce a nursing home to refer patients. Again, a hospice paying room and board payments in excess of what the nursing home would have received directly from Medicaid had the patient not been enrolled in hospice. A hospice paying amounts to the nursing home for additional services that Medicaid considers to be included in its room and board payment to the hospice. Reciprocal referral relationships, essentially the hospice referring to the nursing home in exchange for the nursing home referring to the hospice. The hospice providing free or, again, below fair market value care to nursing home patients for whom the nursing home is receiving Medicare payments under the skilled nursing facility benefit. There is an exception here in consideration to the fact that the patient has exhausted the skilled nursing facility benefit, then the patient will receive hospice services from that hospice. And finally, a hospice providing staff at its expense to a nursing home to perform duties that would otherwise be performed by the nursing home nurse. That's considered a benefit to that nursing home and a kickback. Next slide. Okay, so some compliance program guidance that was issued for hospices. We're going to talk about risk areas first. Again, this was released back in 1999, so it's been around for quite some time. It's available on OIG's website for you to review in full. Some issues that were identified as problematic included in paying incentives to referral sources, for example, physicians, nursing homes, hospitals, that could violate the Anti-Kickback Statute. For example, paying a fee for each terminal illness certification, or providing nursing and administrative or other services to physicians or nursing homes or other potential referral sources. Another problematic area is providing hospice services in nursing homes without a finalized written agreement. You must have a written agreement with the nursing home under which the hospice takes full responsibility for the management of hospice care, and the facility agrees to pay the room and board. Another area was improper patient solicitation activities, such as patient charting. An example of this is a review of the patient records in an assisted living facility without the patient's approval to essentially look for residents who might qualify for hospice services. An additional area is sales commission based on length of stay in hospice. This can cause recruitment of long stay patients who may be ineligible for hospice benefits. Next slide. So some guidance on potential policies that hospices should have in place from the OIG, where that all contracts and arrangements with actual or potential referral sources be reviewed carefully for compliance, very similar to the home health recommendations. And the hospice is not submitting or causing to be submitted claims for which a patient was referred to the hospice pursuant to contracts or financial arrangements that could be in violation of the Anti-Kickback Statute, not providing gifts or free services or other incentives for. Next slide. Offering free or below fair market value goods to induce a nursing home to refer patients to the hospice. Hospice paying room and board payments to the nursing home in amounts that are in excess of what the nursing home would have received directly from Medicaid, and the hospice paying above fair market value for additional non-core services that Medicaid does not consider to be included in its room and board payments. Next slide. Okay, and a fraud alert that was issued on physician compensation arrangements that may result in liability. This was released in 2015. The alert specifically discussed a settlement with 12 individual physicians. The focus of the alert was medical director payments. Compensation arrangements that were discussed in the fraud alert included payments that were varying with the volume or value of referrals and did not reflect fair market value for the services performed. Non-performance by physicians of services called for under the agreement, and payment of salaries of physician office staff. So all things that the OIG thinks are problematic, that it wants hospice providers to be aware of so that you do not find yourself in a similar situation. Next slide. Okay, so some tips and best practices for y'all as we get closer to wrapping up today. Make sure you educate yourself. Do what you're doing today. Listen to compliance webinars, read guidance and available resources to make sure you understand what the requirements are, so that you understand the Anti-Kickback Statute. If you're a home health provider, that you understand Stark Law and all relevant state laws. You should have experienced healthcare legal counsel available to help you in preparing these contracts and reviewing these relationships to ensure that you're in compliance. We also have something that we do like to say to providers on the screen here in that if somebody shows up to your office, everything you say to them as a healthcare provider is evidence. Everything an attorney says to an investigator is an argument. So it's important to have an attorney available that can handle a situation and speak on your behalf so that you don't say things that might be considered statements against interest. If you do not have a compliance plan in place, please get one in place. There is free guidance available from the OIG. It's a great place to start, but it's very, very important to have a compliance plan in place and to actually follow and implement that compliance plan. Next slide. Okay, so some recommendations on your physician relationships. Ensure that your relationships with your physicians is documented. Have those contracts reviewed by healthcare attorneys. Make sure that there's a valid business rationale for the contract and that you're paying a fair market value for the services. Medical directors should only be compensated for clinical and administrative services. There should not be a link between referrals or admissions. Physicians should document their time to support payment for medical director services. This is one of the biggest things that I see when we have an investigation. We have a request for medical director contracts, and we ask the provider how they ensured that the physician was actually working the time and doing what was requested under the contract. And a lot of times that evidence doesn't exist. It's very important that we have our medical directors, our physicians, keep a log of the time that they're working under the contract, that they're working for their medical director position, and what they're doing during that time. That is your best evidence to show that you are not violating the Anti-Kickback Statute or Stark Law, to show that the physician did the work that was being requested under the contract. You have those records, you maintain them in a file for that medical director. It's a very, very, very important piece of these relationships. Make sure you are reviewing your medical director invoices to ensure that the services provided and the hours that are being worked are what would be considered reasonable for the work that's being requested and the amount of money that's being paid. Train your medical directors on eligibility criteria, on the Medicare definitions, and on compliance. You know, they may not have the time to do their own training, so you can make that a part of your training. Bring them into your compliance training. Monitor relationships with your outside referring physicians, their offices, and marketers as a part of your compliance program. Make sure you don't have one specific physician who is a big outlier in terms of your referral sources. Next slide. We also recommend that you screen your physician referral sources and medical directors monthly for exclusions. If they're excluded, that can taint the entire claim. That whole order is bad. So there's a couple of different places you should be looking for exclusions. We have the HHS OIG LEIE available, Louisiana State Adverse Action List, the CMS Ordering and Referring Database. You should also check the GSACM. You should really be checking every available state list as well. That can be very cumbersome. So a lot of providers look to an outside vendor to do that screening for them. Just bear in mind that an exclusion search is required monthly, and this is totally different from a background check. It's a completely separate list, it's a completely separate requirement, and something that the OIG expects you to do every month and before you enter into a relationship. You should be doing it with your employees too, not just with your medical directors and your vendors. Next slide. Okay, some tips and best practices for marketing staff, and I'll try to go through these next couple of slides pretty quickly because I see that we're out of time. For marketing staff, ensure that your employees are true employees. Look at that IRS definition, make sure that they are actually, you know, meeting those IRS definition requirements. You have behavioral control, you have the right to control what the worker does and how they do it. Financial control, are the business aspects of the worker's job being controlled by the company? The type of relationship, are there written contracts or employee type benefits like insurance, vacation, etc. Evaluate your compensation plans for marketing employees. It should not be based on the admissions or length of stay. Even though there is a bona fide employment safe harbor exception, Note that many of the cases involving employees were still problematic. Remember the one purpose rule. If one purpose of that arrangement was to induce referrals, it's a problem. Incentive payments, if any, should not be based on individual economic production. Compensation for marketing by independent contractors should meet the personal services safe harbor. Fair market value, not based on the volume or value of referrals, needs to be a fixed fee determined in advance. And contracted services should be valid services and not a cover for referrals. Next slide. Make sure you're separating the marketing function from the intake and admissions function. Intake and admissions personnel should not be receiving bonuses based on newly admitted patients. Stay away from quotas for admissions. Don't fire people for failing to meet goals. That can be very problematic. And you're probably identifying a whistleblower right there. Beware of excessive focus on numbers and revenue. Make sure you're checking your referral patterns again, making sure you're not receiving more than about 20% of your referrals from any one physician unless you're in a rural or underserved area. Train your marketers and admissions and recertification personnel, and monitor the marketing practices of your independent contractors. These people are operating on your behalf. You're going to be ultimately liable for any fraudulent practices. Next slide. And finally, avoid offering free or discounted services to other healthcare providers or facilities in connection with your home health and hospice patients. Next slide. Just a note on facility relationships, make sure you're documenting any relationships between your agency and any facility. These arrangements need to be structured compliantly. There need to be signed written leases for at least a year. If you're a hospice and you have a nursing home agreement, that also needs to be a written agreement, needs to be signed. It needs to address the hospice responsibility for care and the nursing home's responsibility for room and board. Next slide. Of course, when in doubt, reach out to qualified healthcare attorneys. That's going to be the best place to go to look at your specific issues, your specific concerns and questions, your specific relationships. Please ask before proceeding into a relationship or a contract. It's so much easier to identify an issue at the outset as opposed to digging out of it once we're in it. Next slide. All right, and that's all we have for you today. Do we have any questions?
No, we have no questions today. Nobody posted questions.
Okay.
Yeah.
Well, wonderful. Thank you all so much for joining us today. John's contact information is on the screen as well as mine. Please feel free to reach out to us via phone or email if you do have any questions or need any assistance.
Yep.
Thank you, everybody.
And thank you for attending, and we'll circulate copies of the PowerPoint slides probably tomorrow, and we hope that you can join us next month.
Thank you.
Take care. Bye-bye.